Hi, Mr. Arendt.
Morning.
So I think we can slowly start. It's 10:14, but I think I should start. My name is Thomas Hoeren. I'm your teacher. I'm not a teacher. I'm your colleague in making you clever in terms of LDE. We have this session today. We are speaking more about GDPR and finishing the GDPR. Next week, there will be Sergei Jobenadze from Tiflis, a worldwide expert in the area of internet defamation law. I'm really happy that he is willing to speak to you, for instance, on hate speech and fake news. All these ways people are defamated in the internet. In 2 weeks, we have a final session where I'm finishing the overall view and I'm more talking about the written exam. So that finishes our next sessions. Today, as I said, I'm speaking about the GDPR again. So I will collect my slides within a second. There it is. So you remember I've spoken last week on the examination matrix. How can you examine a case which has to do with personal data according to the General Data Protection Regulation? There is one idea in the GDPR which is very helpful to understand it. That is Article 6. That is the main, really core regulation of the GDPR because it says if you are in doubt whether processing of personal data is allowed, forget it. In doubt, no, unlawful. But this principle of doubt only applies in certain specific circumstances. You have to ask yourself preliminary, where can I sue? And dependent on the question, where is the court, which you find the court chooses his rules on conflicting laws. So the court has to decide whether they want to apply the GDPR. That are preliminary questions. Then you have to ask yourself, are there special laws which may be applied? For instance, the topic of next week, defamation law, has an impact in data protection as well. As I said last week, telecommunication law, e-privacy, the regulation of churches are all regulated by special laws. Then you have to ask yourself 3 general questions. Do we have to do with personal data? Are these data possessed? And there are rare reasons for excluding very small parts of data processing. If these 3 elements come together, we apply the principle on only if. We call that in Germany the principle of general prohibition with Erlaubnisvorbehalt, because I mentioned in one slide the term EV. That means Erlaubnisvorbehalt. In rare exceptions, there is a permission that you can store data. These exemptions are regulated as well in Article 6. And then we skip my slides, which I've spoken about last week. to come to these rare exceptions where data may be processed. So that is that slide. You can make a reference in Article 6 to consent. Consent is a Magna Carta of data protection. If you have the consent of the person concerned, you can do whatever you want. You can process data if it is necessary for the fulfillment of a contract. You can refer to legal obligations in which it is necessary to store and process personal data. Especially the state can make a reference to the fulfillment of a task in the public interest. And this is very important, necessity to safeguard legitimate interests. This is very, very broad. For instance, we have seen that it allows, for instance, skip, to store data within a concern, within a multiplicity of corporation bound together by corporate law. So we have a group privilege regulated as part of legitimate interest. Legitimate interest is as well direct marketing. This is very surprising when you notice that I mentioned in the part of unfair trade law that according to German, French, Austrian law, direct marketing is forbidden unless you have prior express consent in unfair trade law. That's a different principle in data protection law, because you can use data for direct marketing unless the person concerned explains, no, I don't want to be object of direct marketing campaigns. You can object according to Article 19, that's called opt-out. So the question is, can we use the opt-in principle of unfair trade law, or do we use for direct marketing opt-out? The rule in Germany and Austria and France is we take the most restrictive regulation in unfair trade law. So opt-in is the main rule in Europe. At the end of last session, I've spoken about AI. How can we say AI can be allowed the training of personal data? Is it free or not? The general principle, of course, is no. Exception if you have a consent. That's very unreal to ask everybody for consent that his data are used as training material by ChatGPT. So there is one decision, the Court of Appeal of Cologne. He said, this court said, that can be part of legitimate interest. Then you have this exemption for legitimate interest, unless you can prove that you have an overriding interest in getting your data protected. This decision has been used by Ms. von der Leyen to say in the digital omnibus, which we are talking about next semester. In general, AI is based and valid on the model of legitimate interest. So she wants to open data protection for being more liberalized as to AI and ChatGPT. So that's only what I said last week. Now I'm coming to new questions. We have totally different model in the GDPR if we come to special sensitive data. That has to do with France, and France has this model of onion. You remember the onion theory? In the middle, you have very, very sensitive data. In the outer part of an onion, you have normal data. And in the real outer part, there are neutral data which you can use. This model of distinguishing between sensitive and non-sensitive data is part of the French model of data protection. So there are certain data which are highly, highly protected. For instance, racial origin, political opinions, trade union membership, genetic data, biometric data, and health data. And this is a parallel world because Article 9 says it doesn't matter what Article 6 says. If you have to do with sensitive data, the use is prohibited. Prohibited. That's harsher than Article 6. And there are exceptions, but these exceptions include, for instance, express consent, but not legitimate interest. So the question of Ms. von der Leyen in the digital omnibus, which we are talking about next term, is, does that mean that Article 9 prohibits the use of medical data for AI? In fact, if you take the wording of Article 9, you cannot use medical data as part of ChatGPT. So von der Leyen wants to open Article 9 and argue that AI use for training is allowed even in the circumstance of medical data. I mentioned that here. Very radical. So here you see the reasons why sensitive data can be processed, explicit consent. You can process, of course, medical data, health data in labor relations or social security. You can use this data for vital interests of the person concerned. And are very rare exemptions, very high-level exceptions from the rule. So that is all. Next topic, that is a misplaced topic in the GDPR, automated decision machines. It has to do with French law as well, because in France there was a situation where the decision upon asyl was made by a machine, by computers. So the computer decided if somebody can stay in France or not. That was the reason why the French government integrated in the Data Protection Act a specific regulation that a machine can never make a decision automated and which has an effect on a person concerned. That is very important if you have AI, because nowadays Schufa and the other big companies scoring person concerns regarding their banking data, they are using AI. So a machine is asking, do we have a high score for getting credit in a banking institution, and this AI is deciding upon your credibility. So we had it in Germany as well. The problem remains it must be a decision based solely on an automated processing. What does solely means? What is happening if a human is deciding at the end, but with the help of AI? Is that forbidden or not forbidden? The ECJ decided that matter in the case of the Schufa and said if the main elements of decision are made by a machine, that's still solely on automated processing and forbidden. Of course, Ms. von der Leyen says in the digital omnibus, oh, perhaps we should open this harsh regulation. A decision may be based solely on automated processing only where the decision is necessary for entering into a contract, regardless of whether the decision could be taken otherwise than by solely automated means. That means a machine can decide whether to get a banking contract, and it has nothing to do with the fact that some banks are deciding that by a human, whether a human can decide that matter. So that is Article 22. Then we have the very important principles of data protection. They are mentioned in Article 5. To say it honestly, these principles are very good, very broad, but nobody knows the value of these principles. What is happening if you are acting in a way contrary to these principles? Can you be sued? Nobody knows. These principles, 5, 6 principles, I've mentioned them here. Talk more about the details. The first principle is legality. You can only possess data in a lawful manner. Second principle, you can only possess personal data in good faith. Third element, you can only possess personal data in a transparent way. So you have to inform the data subject whether and how his data are processed. Very important principle. Data processing must be held to the minimum. You can only store data which you still need. If the necessity is away, you have to stop. You can only process personal data if these data are factually correct. So you have to check with the usual care whether the data collected is correct. You have to stop storing data in the moment where you don't need this data anymore. So the storage of personal data is only allowed for as long as it is necessary to achieve the purpose. Take, for instance, a big insurance company. I worked as a student for a big insurance company in Münster, and I found millions of data in the cellar. I said, what do you use these data for? They are sometimes 30, 40 years old. is that it's simply storing them without any purpose. So you have to erase data, and you have to provide an erasure concept for personal data. Data can only be used in a confidentiality atmosphere and taking care for integrity. And the responsible person is responsible for proving that he has stick to all these obligations of Article 5. Then there is this problem of coupling. That's always very harsh requirement. Sometimes big companies tend to say, you give your consent that we can store your data, and then we invent a new purpose for storing this data, and we could want to combine these two purposes. That was forbidden in the first discussion on the GDPR. Now it's open, regulated very openly. The controller must check whether a change of purpose is compatible with the original purpose. So, next topic, very important topic, the hypertrophy of duties. Hypertrophy means there is a lot of regulations in the GDPR on duties of the controller, the person who is controlling the storage of personal data has to take care for a lot of obligations which were put on him. For instance, the obligation to obtain consent, the obligation to inform data subject, a lot of obligations. You see it here. It doesn't stop with obligations. The problem is to combine these obligations with general principles of contract law. That was a part of a doctoral thesis program. Somebody in our institute has written 400 pages dissertation on the question, can we combine our general civil law with these obligations? For instance, in the matter of impossibility, do we apply general rules on impossibility? The most important duties and rights are here mentioned here. According to Article 12, you have to provide transparent information. Then we have to write Article 14 and 15 to get access to data, to get the information, so the data subject can ask for getting a copy of this data. There's a right of rectification and erasure. And let me talk on these rights. The first is the right to inform the person concerned without any question, do I want this data? You have to inform as a processor which data do you use in your machine. You have to inform very quickly, free of charge, and you can provide icons, small things. So, nevertheless, the person concerned has the right to ask actively for information, There is a long list of the data which the processor has to give to the person concerned, and these rights are very harsh. I said to myself, when you want to telephone to a doctor and you speak to him on telephone, according to the model of information, the doctor has to say, the data protection officer here don't speak longer is Mr. Peter Müller. You can reach him there. The purpose of processing data is the preparation of a treatment contract which stores data for 10 years and so on. It's very, very boring and annoying for a doctor to give away all these rights. So, and not only to give these rights, this access one time, but at appropriate intervals, you have to inform the public and the person concerned. For instance, annually, you have to inform the person concerned in the form of a copy or by providing remote access to a secure system. You have to inform the person concerned about the recipient, storage period, rights of data subjects, and so on. In this moment in Europe, we have a separate business model that people like to ask for access and to annoy companies by simply saying, I haven't got that information which I have asked for. You have to pay compensation for violating my right of access. There are even companies who provide the person concerned with formulas, schedules for asking right of access. So the main question is, how do we get rid of the right of access? And it's not very easy to say no. Now it's enough to have asked 5 times for access to your personal data. No, it's enough. There is only 4 models for saying I don't want to give access. One is a question of disproportionate effort. So if somebody says, I worked 20 years at the IBM in Stuttgart, and I want to know in which files at IBM I am mentioned with my name. So you have to ask a whole um, special force for helping to find out which data have we stored and to blacken certain parts of the documents and to prepare access. That is a huge effort, and you can sometimes say, no, it's enough. Then we have a chance to say this right of access is used in an abusive way. For instance, if it's manifestly unfounded or the application is to be considered excessive. If somebody says, I want to get access, but he doesn't specify what he means with that, then you can even say, I don't want to give access. So you see the problem, for instance, in a relatively new case from Berlin. Somebody, a passenger in the tube, in the railway, said, I want to get all video recordings of my journey. So the Deutsche Bahn and the S-Bahn should check where is this person stored with his personal data and images. That was denied by the court, and the court said this is excessive and cannot be given. So you can understand that Ms. van der Leyen in the Digital Omnibus was too as well concerned about the abuse of rights of access. And so she refined criteria for rejecting excessive or abusive access requests. So in the future, this refusal and rejection of requests of access is regulated in the GDPR, perhaps. Another right, that was all on right of access to data, is the right of erasure, the famous right to be forgotten. That's regulated in Article 17. So personal data must be deleted without undue delay if these data are no longer necessary for the purpose for which it was conducted, if the consent is revoked, if the data processing was unlawful, and or the erasure was ordered by law. Then it was part of this famous decision of the ECJ, which I mentioned last week, on the right to be forgotten from 2010. That was Mr. Gonzalez, a famous lawyer in Spain, and he complained that all his old files could be found regarding his insolvency. There the court said it's impossible that these old files can be found. Privacy includes the right of a data subject to request that these data are deleted and that search engines have to de-index results for a search based on their name. The right to be forgotten, as it was a nice term. I was always dreaming of being forgotten, but Mr. Gonzalez as well. So that was all on the right to be forgotten. Then are the famous rights of the person concerned, of the data subject. Apart from that, we have one more problem with the GDPR. Who is responsible for all these duties? Who is a partner of the data subject? Who is responsible for deletion, for giving access? There are two categories, the so-called controller and the processor, that are terms from EU Pigeon. They are not very clearly regulated. There's on the one hand the person who's controlling the means and purposes of data processing. And on the other hand, there may be somebody who's only working on behalf of the controller. So the technical provider is called the processor. It's very problematic to decide who is controller and who is processor. So the distinction only asks who is deciding upon the means of processing and the background. The definition in Article 4 says the controller is a person who is determining the purpose and the means of processing. So, does that mean, for instance, if I'm using Facebook for my Facebook website, I'm determining the purpose and I'm choosing the means for processing this data. Is a user of Facebook a controller and Facebook itself is only a processor? That was the case of the ECJ, where the ECJ said both the user of Facebook and Facebook is controller. That's the so-called co-controller. So even two persons can control. So if we have a controller, he is responsible for appropriate technical and organizational measures. That means he is taking over the responsibility for things happening in the section of the processor. If I have two controllers, situation of Facebook and the user, I have a joint controllership. That means two companies, two legal entities have a joint and civil liability. Things even get worse if the controller is outside the EU. It's very restrictive and regulated in the GDPR because the controller must have a written declaration about a representative in the EU if he wants to work. The controller has as well provide an order processing strategy. So he has to take care that his orders for processing data are made in a legal way by the processor. So he has to provide sufficient guarantees, a written consent for subcontracting, and a contract with the processor. This model contract is clearly defined in the GDPR, subject matter, duration, data purpose, and there are other requirements, in particular for the model contract. So, The next topic we have data security. That's a very important topic we will discuss in summer term. There will be a long section of 2 or 3 hours on data security. What is data security? Technical and organization measures which are to be provided by the controller. There are the famous TOMs, technical organization measures. I've made a video on TOMs, which you can find on YouTube. TOMs include encryption strategies, confidentiality requirements, testing, pseudonymization, access to data, and regular testing. This is a German slide. If you see it now German, I only want to explain what that means. Data protection is not 100% identical with data security. So here you have on the left side data protection and on the right side data security. And there's one small area which is regulated by the GDPR where data protection and data protection are working hand in hand. But there's far more technical matters in the area of data security on the right side. So then data breach notification. That is an idea from the United States. When you have experience a security incident, when your data are being hacked by hackers, you have to inform the supervisory authority about that incident. So in the past, the big companies have said, I don't want to inform anybody on our problems with security. But according to Article 33, you have to notify to the supervisory authority about a breach of security leading to destruction, loss, alteration of personal data. You even have to inform in high-risk cases the public. That means the data subject. So you have to say in the press, sorry, we have big issue with security and data are misused by hackers. Then we have another important topic, data protection impact assessment, DPIA. So if you have a processing of the personal data, which have a certain risk, you have to check the risk in advance. You cannot say, I've checked the risk when the risks are coming into existence, but you have to check the whole system before you started when there's a likeliness of a result in a high risk. So impact assessment, for instance, includes evaluation, scoring, systematic monitoring. Does my system include sensitive data, data processing on a large scale? These are cases where you have to make a data protection impact assessment. So, we are rushing through the world of GDPR within 2 hours. But we need that topic in the summer term, because in the summer term we are speaking about specific problems in compliance regarding AI and data protection. Then we have a certain guy or woman called the DPO, that's the Data Protection Authority. There's somebody which has to work as a kind of officer in the company responsible for supervision of data protection and privacy. As a German model, we have a nice job. If you want to become rich, you have to ask a big company, do you have a DPO, an officer of data protection? It's a very nice job because you get a high level of money and after that LDE education, you can ask for a job in the area. So a designation must be made by a public authority, by a company whose core activities require regular and systematic monitoring. If we have to do with large scale of sensitive data, and where required by member states in Germany, we have an obligation to install a DPO if we have more than 10 persons working in the area of data processing. So it's mandatory for companies which with a large HR department, and you are protected as DPO against a dismissal. So you are protected against an CEO wanting to abolish you. The DPO must not be, of course, head of the IT department, must not be work council, must not be part of HR, not audit and legal. So you must find somebody who can really do an independent job. You can install a kind of group data protection officer. So if you have a group consisting of a controlling company and the company is dependent on it, you can install one group officer, that's all. A good job, as I said, is worthwhile considering it. So, next topic, apart from the DPO, we have, of course, a national supervision authority. Article 51 provides that each member state has one or more data protection authorities. They are responsible for data protection and free flow of data. They need to be independent. There's always complaints that they don't have sufficient people and money for doing their jobs. Their task is, of course, as authorities, to monitor private industry in their country, to promote public awareness, and to deal with complaints. They have investigative power, corrective powers. They can, for instance, set up a fine against the company. And it's possible to sue against the data protection authority, even if they have done nothing. Even nothing can be part of the proceeding in front of an administrative court. We have one super organization as the European Data Protection Board. In the European Data Protection Board, there's the principle of one state, one vote. We always have the problem that the big companies like Facebook and Google know that it's good to have its seat in Ireland, because in Ireland in the past there was no sufficient Irish data protection commissioner. So there were heavily complaints against this situation. Now we have a European Data Protection Board, and who is administering all this work of national data protection authorities, and who is publishing guidelines in order to understand the GDPR. Their work is, of course, very important because we have problems with TBDF. What is TBDF? Trans-border data flow. So data do not only are transferred within a country, but trans-border to another country. It's no problem if this country is situated in the EU, because Article 1.3 says we are focusing on the free movement of personal data within the Union. So the transport of data flow is free within the EU. But the problem exists, of course, with the United States. Because the United States doesn't have a clear data protection policy. So the Commission planned in 2015 to have a safe harbor agreement. That means you have a seal. Yes, I'm American. I'm proud of that, but I stick to the rules of the GDPR. So a guy called Schrems was responsible for suing against the safe harbor principle and said they claim that they have a sticker saying we stick to the rules of the GDPR, but it's only a sticker and it's not reality. So in fact, data are misused in the United States by authorities, by the courts, by companies. So stop any attempt to make agreement with the United States. The court said, you are right, Mr. Schrems, that is forbidden. And in the GDPR, the GDPR says we can only give data to third countries if they have an adequate level of protection. So you need a decision of the Commission that this third country has an adequate level of protection. For instance, the United States doesn't have anything adequate. They don't have a level and they don't have protection, nothing. We'll talk about the effect of that in a minute. If you don't can rely on an adequacy decision, you can have appropriate safeguards. There are other tools which you can use. You can have binding corporate rules. That will be explained within a second, and only in very, very specific situations you can transfer data to third countries without any adequacy decision or others. So binding corporate rules are, of course, very helpful. If you have a big corporation, they can arrange these rules, but these rules are checked by each authority nationally and by the European Data Protection Board. So it's very, very complicated and long-lasting to develop such a BCR. Derogations are only possible, for instance, with the explicit consent or where it's necessary for the performance of contract. Take, for instance, the example, somebody makes a mistake and wants to do his holiday in the United States. You need to send the hotel data, the rental data for the car to the United States, of course, because it's necessary for performing a travel contract. So, and you can at least stick to model contracts which the Commission has developed for the situation of controller processor or a transfer of data between two controllers. You have certain model agreement which we can use at the end as an appendix to a main contract. If we take the United States, they had safe harbor that was forbidden by the ECJ. Then they have had a similar thing called the privacy shield that was forbidden as well by the ECJ on request of Max Schrems. Then now we have a third model called the EU Data Privacy Framework. That has been accepted in 2023 by the Commission as an adequate instrument for regulating TPDF, but the US is now adequate. No need to have BCR or a model contract, but we have Trump. And Trump has made so nasty decisions that Mr. Schrems is now preparing a Schrems III decision of the ECJ in order to say Trump is asking his authorities for getting access to European citizens, taking, for instance, ICE or civil court proceedings or home office needs. And there's Schrems III. So it's expected that Schrems is preparing an action against the EU-US data privacy framework, and he's complaining about US surveillance a lot. And the US authorities are meanwhile changing the mentality. They are saying, why are we only reacting towards the European authorities asking for data protection? We have our own problems in privacy and data protection matters, and Europeans have to stick to the US rules, federal rules, and state laws as well. For instance, if you transfer data to a country of concern, that is China, Russia, Ireland, Iran, and North Korea, that is forbidden for US companies by US law, but this US law does also bind European companies. Or take California. California said, we want to control European companies in the way they are handling data related to California residents. So you have to open books and show what you do according to Californian law. So, T for peace and happiness. We have more than 70 slides to follow. A very good topic is who is liable for violation of the GDPR. You can ask for courts, judicial remedy, according to 79. You can even ask for compensation and liability. And compensation is a very important topic because in the decision of the Österreichische Post, the ECJ said liability does also include non-material damages. It's not a mere breach of GDPR, but as well the fear, anxiety, distress, loss of control. That's all part of non-material damages. You can claim to have suffered reputational harm, discrimination concerns, or a reasonable feeling of vulnerability. So it's very, very vague term damage in the area of GDPR. So you cannot ask for punitive damages, nevertheless. You can only ask for compensatory damages, but as I said, this includes non-material damages as well. Consumer associations can also claim and sue against violation of the GDPR that has been decided by the EChR 4 years ago. And in a relatively new case, the ECJ said that can be even part of unfair competition law. So if you are violating GDPR, it gives you an unjustified advantage compared to the situation of legal competitors, and that's unfair. There's an unfair advantage which leads to a case under unfair competition law. So that's the harshest data protection authority in the world, because any violation of GDPR can, in theory, be part of unfair competition law. And another way to react, companies that violate the GDPR are subject to a fine up to 4% of their annual turnover. That's really quite a lot. We had seen from France and Sweden harsh fines which are fixed to the detriment of big companies. So that's all for that. And now I'm speaking about additional super problems. I call them super problems, which are not regulated and cause a lot of problems. First problem is, what does data protection mean in the light of the discussion on data ownership? Who is the owner of raw data? Can we use data protection for defining who is a person or who owns raw data? It cannot be said that this is part of data protection, because data protection is only right to protest against processing your data. It doesn't give any so-called Herrschaftsrecht. So it doesn't give you a right similar to owner. So it's very controversial. Where does the concept of data ownership can be found? I've said it may be perhaps found in traditional property law concept or even in criminal law, but not in data protection law. The way the situation can be seen regarding unfair competition law and GDPR is not so easy, because you cannot say that every violation in detail is a violation of unfair trade and unfair competition law. The GDPR violation does need to give somebody an advantage in business from the marketing perspective. So simply to forget to install a DPO, a data protection officer, is not a violation of unfair trade law. But of course, if you're violating the online marketing concepts of the GDPR, that gives you a direct advantage to your legal competitors. The relationship between the GDPR and competition law in general, especially the DMA, which we are talking about next term, is also complicated and will be a topic of discussion next term. The GDPR and Data Act has a lot of overlaps, which are not very clearly regulated. And the overlap between information security and GDPR needs further considerations as well. So, last topic on my slides. We have spoken about the GDPR in a nutshell. Now we need to have a 10 minutes look to the European Convention on Human Rights, because even this convention has an impact on data protection. So you have to always distinguish between the Charter on Fundamental Rights of the European Union compared to the European Convention on Human Rights, ECHR. The ECHR is a separate convention which is not only important. I want to have a look on that. Sorry. Not only an impact on the EU member states, but on 46 member states of the Council of Europe. That, for instance, includes Turkey, which always wanted to become a member of the EU, is unfortunately not, but is a member of the Council of Europe. This European Convention has a high impact on European rights. It's a bridge between human rights protection and digital protection. It's regulated by the European Court of Human Rights. Again, this has nothing to do with the ECJ. The European Convention does not have an explicit fundamental rights to data protection, but it has a wording in Article 8. I think I mentioned that here. A right to respect for private and family life, and this has been interpreted by the European Court on Human Rights in a way that it includes protection of correspondence and personal data. So it's directly relevant for data protection. So I want to show you the relationship. So the European Court of Justice look towards the European Court of Human Rights, what they are doing. So the European Convention is a kind of minimum right. It has to be integrated by the ECJ as well in a harmonized way. But the ECJ is, of course, free to do more. It has an indirect direct effect between states, but it has an indirect third-party effect through interpretation in accordance with the Constitution and the Convention. I only want to show you some of the cases decided by the European Court of Human Rights. For instance, the case of Klass and others against United Kingdom. The Federal Republic of Germany integrated certain change in the telecommunication law, and this law allowed secret surveillance measures without informing those affected. Certain plaintiffs complained and said this violates their right to respect for private life. And the European Court said there's only allowed to control private telecommunication based on strict conditions which are prescribed by law and necessary for a democratic society, and secret surveillance is therefore be illegal. So take another case only to show you the cases. Case Leander against Sweden. What happened? Mr. Sweden applied for a job in a museum in Sweden. The appointment fell through because negative information had been stored during a secret security test. The person concerned was not informed of the exact content of the data, and he said, "This is a clear violation of my rights under the convention." So, was the ruling? Secret security checks must be possible for a democratic society, but they have to be based on a legal basis and be proportionate. In that case of the under, Sweden offered sufficient protection, so the court found no violation of the convention. So when you have time, I would recommend that you check all these cases and have a look. It's fascinating what the court has said. So especially since he started to decide since 1980, so a little older than the ECJ. So that's all I want to say. I hope there was the time worth and you liked my consideration on the GDPR. Next week, we have the section on defamation and personality rights by Sergi, and then we have the final session, Q&A session as the 3rd of February. Are there questions which are left? Are you satisfied? Then I wish you a good start in the new week. See you all in perfect shape, a nice smile, like Miss Kraus, she's always smiling. So, see you.
Thank you, sir. Bye-bye.
Thank you.
Bye-bye.
See you.
Thank you.
Very
Bye.
much.
Thank
Bye-bye.
you.
Bye-bye.
Bye.
Bye.